Hello everyone, I am CS Ayushi Jain. Today, the topic is Amended CSR Provisions under the Companies Act 2013 after the latest notifications by Ministry of Corporate Affairs with respect to Section 135 and Company CSR Policy Rules 2014. The Ministry had set up a high-level committee on CSR in 2018 by the then Corporate Affairs Secretary for amending the law aimed to strengthen the ecosystem of CSR by improving and strengthening disclosures and by simplifying compliances. It also aims to address the inadequacies of the present CSR architecture by removing ambiguities, bringing in objectivity, and by simplifying the language. In a significant overhaul of the corporate social responsibility rules, the Ministry of Corporate Affairs has introduced various notifications and has marked several changes in the provisions. Let's quickly know what is the applicability. Any company having net worth of 500 crore rupees or more, or turnover of 1000 crore rupees or more, or net profit of 5 crore rupees or more in immediately preceding financial year are required to constitute the CSR committee and to spend as per the provisions. The spent amount is to be calculated as 2% of the average profits of the company made during the 3 immediately preceding financial years. If the company has incorporated less than 3 years before, then the number of years has already been elapsed are to be considered for calculating the average net profits. Now the stepwise process for the CSR compliance as per 135 section and the rules thereunder. MCA has introduced e-form CSR1 that is required to be filed by the societies or trusts who are implementing the projects of various companies. After that, unique registration number has to be given for each CSR project, and a 3-year limit has been specified for any CSR project to be given a number. This form, however, is not for the CSR projects already approved prior to April 1, 2021. Now the next step is CSR committee is required to formulate and recommend to the board an annual action plan for CSR covering the CSR projects and programs, manner of their execution, monitoring and reporting mechanism, and need for impact assessment. Some important points for this provision: where the amount to be spent by the company does not exceed 50 lakh rupees, the requirement to constitute the CSR committee is not applicable. Then the board has to undertake all the CSR activities, including this annual action plan formulation and approval. The second is the board may alter such plan in the financial year on the basis of recommendations of the CSR committee for reasonable justifications provided to them. Now there can be 4 situations basis this annual action plan. In all these 4 situations, some provisions are common. The first one is annual report on CSR activities that is required to be attached to the board report of the company. Here 2 different annexures have been prescribed. The first is Annexure 1, that is for companies reporting the CSR disclosures in the board report for financial year commenced before April 1, 2021. And the second is for financial years commencing on or after April 1, 2021. The second compliance is to mandatorily disclose all CSR projects and programs as approved by the board besides the CSR committee's composition on the company's website for public access. Next is the requirement of impact assessment. Now here every company having CSR obligation of 10 crore rupees or more under section 135(5) in the 3 immediately preceding financial years shall undertake impact assessment. It is to be done by an independent agency for the CSR projects having outlay of 1 crore rupees or more. A company undertaking impact assessment may book the expenditure towards it for that financial year which shall not exceed 5% of the total CSR expenditure or 50 lakh rupees, whichever is less. That means the expenditure done towards impact assessment can be included as CSR spend, but that shall not exceed 50 lakh rupees in any scenario. Now, where the company has spent excess amount in any financial year, the company can set off that excess amount in succeeding 3 financial years, provided the company has passed a board resolution to that effect. Also, the excess amount available for set off shall not include the surplus amount not spent by the company. Any amount remaining unspent on ongoing projects undertaken by a company in pursuance of CSR policy shall be transferred within 30 days from the financial year end to a special account. This special account is required to be opened by the company with any scheduled commercial bank named Unspent Corporate Social Responsibility Account for a particular financial year. Such amount shall be spent by the company in pursuance of its obligation within a period of 3 financial years from the date of such transfer. If the company fails to spend the amount, then the company is required to transfer such amount to any fund in Schedule 7 within a period of 30 days from the end of third financial year. Ongoing projects means a multi-year project undertaken by the company towards fulfillment of its CSR obligation, having timelines not exceeding 3 financial years. Now the last case is when the company has not spent the amount and has not any ongoing project. Then the company is required to transfer the said amount to a fund specified in Schedule 7. Now MCA has prescribed that until a fund has been specified in Schedule 7, the unspent CSR amount, if any, shall be transferred by the company to any fund included in Schedule 7 of the Act. A detailed article has been posted on my website ayushij.com covering penalties, punishments and other provisions in this regard. Thank you.